Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In the last video, we just have discussed the positive morality or the concept of morality in the framing of the legal work. The positive attitude was shown in the case, so many cases of the Indian Constitution. You may get a question. So explain the positivist view in the Indian Constitution. You all know that the positive view, the element of good governance is by approach of the so-called rule of law. Legal positivism, it is understood as the valid legal norms precisely created by the Constitution or the basic norms. Yesterday we celebrated the Constitution Day. So according to Professor M.L.A. Hart, the legal law, definitely it is a command. So normally the legal law is different from sociological or historical inquiries. Decisions can be drawn from precedents also. So this is what he has stated regarding the positivist view. Right. Now positivism is observed in so many cases. Legal positive, right from the case of Shankari Prasad versus State of Bihar, Sajjan Singh, I.C. Golaknath and Keshavananda Bharathi. These four cases, they are the best examples of legal positivism. At the time, when the amendment was there, that the property should not be enjoyed by only monopoly on the property should not be there. Garibi Hatao program. So actually, the article in 19 was tagged on to 300A. So at that time, lot of disputes were there. The courts were flooded with the civil litigations like Shankari Prasad, Golaknath. So in some time, a positive view was taken that since Article 13 Clause 2 deals with the so-called law, amendment is also law. So the Parliament cannot amend the law. In Golaknath case, they said that yes, since it is the preamble is also part of the Constitution, yes, they can amend the Constitution. Ultimately, in Keshavananda Bharathi case, the legal positivism, 1973, it has been observed that the amendment can be made to the Constitution, but the basic structure should not be disturbed. Yes, this is a positive view. You can mention this case. So, in 1960, Golaknath case, 1973, right, this Keshavananda Bharathi case. And another positive attitude, this is in the case of Indira Gandhi versus Narain, 1975. May she be the Prime Minister of India. We just don't care. When she has violated the code of conduct of elections, she has to be punished. This is the judgment given. So this is what is called legal positivism. They need not be biased by the party in power or the person in power. The Supreme Court held that it was the subversive principle of free and fair elections. So it has violated the basic structure of the Constitution. Therefore, the election of Indira Gandhi was held to be void. Finished. She has to go for. So basing on the petition filed by that Narain. So another case, ADM Jabalpur. Another case, Minerva Mills, very famous case of 1980. So they all clearly stated that the 39th amendment of the so-called amendment of the Constitution is against to the or violating the basic structure doctrine. Right. Now, another positive approach is, please remember, S.P. Gupta versus Union of India, 1982. So actually, from that time onwards, the pill movement started. You know the pill. Justice P.N. Bhagwati is the propounder of the so-called public interest litigation. So it is an exception to the principle of locus standi. Anybody can file a pill, of course, if it is in the interest of the general public. So please remember, any social action group can file an application. S.P. Gupta versus Union of India, 1981. Actually, 1982 it is written here. But what it deals with the transfer of judges case, or we can call it as a first judges case. And please remember, the rights, the positivist view. So no doubt a person is arrested. With that, all rights have gone. No, only except the moment except the right to move, all rights will be there. The prisoners should not be handcuffed. The prisoners should not be kept in jail, and they should not languish for years together. So this was stated in very famous cases like MM Hoskote versus State of Maharashtra, 1978. Even 39A, yesterday we discussed Article 39A, free legal aid. Yes, definitely it is legal positivism, positive attitude. The attitude of the government is that nobody should suffer for lack of the so-called legal advice. No doubt we know that legal advice has become costly, therefore everybody should have the approach or should have the access to justice. It is provided by Article 39A of the Constitution of India. Yes, definitely it is a legal positive view in the Indian Constitution. In Hussain Ara Khatun, Sarala Mudgal, so many cases are there. Hussain Ara Khatun. So the prisoner should not be languished in jail for no fault of them. And actually, it is the speedy trial is a fundamental right. Article 21, right to life and liberty. Speedy trial is one such a right to life and liberty. Environmental protection. Article 51A, duties of the citizens. You have to protect the environment. You have to preserve the environment. But what is happening today? In the present days, the so-called industrial development, it is actually spoiling the arena or environmental balance. No doubt, definitely the industrial growth should be there on one side. At the same time, the environment should not be polluted. So, whenever environment comes, Supreme Court has taken a positive view in number of cases like MC Mehta versus Union of India, Ganga pollution case, Kaveri tanneries case, so many cases are there. So these are all positivist view. And lastly, suppose a right to life. If a person is kept in a permanent vegetative stage and there is no hope of recovery, then the person can be ordered the so-called passive euthanasia. This is also a positive attitude. What is the thing we are going to get if the person is alive? No. So definitely better let him have a peaceful end of the life. So passive euthanasia. Aruna Shan versus Union of India, 2011 case. So please remember, these are all positive attitude. That means the Supreme Court of India acted as a reformer. No doubt. Some people say so-called judicial activism. It is actually distorting the constitution. The judiciary is interfering into the steps of the so-called administration. But some people say it is good because they are entering the arena only in times of necessary. Otherwise, so A.K. Gopalan case, what happened if the Supreme Court has not interfered, definitely it would have been sent to jail for actually publishing the so-called communist material or something like that. J.K. Bhim Singh versus State of Jammu and Kashmir. At the time itself, they have given 50,000 punishment because of the illegal detention of an MLA who has to attend the assembly. So please remember. And Maneka Gandhi, this is not the least. Maneka Gandhi case, very famous case. Their right to know as to why her passport has been impounded by the passport officer, even under section 12B of the Passport Act. Yes, Supreme Court clearly ordered the person to write the reasoned decision or speaking order as to why I have impounded the so-called passport of Maneka Gandhi. Likewise, the courts are taking the positive attitude. Indian Constitution, it is having the positive attitude. If the question comes, please don't forget to mention the case laws. List of case laws we have discussed. Main important, Keshavananda Bharathi, EDM Jabalpur, then Hoskote, then Hussain Ara Khatun, and lastly Maneka Gandhi or Narain case. All these cases, if you are able to mention the years, you need not mention. If you are able to mention the case laws, then definitely the examiner will be under the impression that you know Constitution very well, and jurisprudence also you will get good marks. So with this I am concluding. Thank you very much.